Commercial contract terminations.
445. How are terminations conducted under commercial contracts?
Commercial contracts may be terminated for convenience or for cause. The Federal Acquisition Streamlining Act, FASA, of 1994 established a government-wide preference that government contracts acquire commercial items whenever possible. The procedures for terminating commercial item contracts are contained in FAR Part 12. Figure 8.2. Factors to consider before terminating a contract. For default. The need to terminate a commercial item contract for convenience is no different from that associated with non-commercial item contracts. For example, a commercial item contract can be terminated when the government no longer requires the item. The difference between termination of a non-commercial item contract and a commercial item contract lies in the applicable settlement procedures. When a CO terminates a commercial item contract for convenience, the government must pay a percentage of the contract price, reflecting the percentage of work performed prior to the notice of termination, and any costs that the contractor can demonstrate resulted from the termination, for example, restocking fees charged by a supplier when the contractor returned purchased parts. The contractor may use its standard record-keeping system to demonstrate such costs. Under commercial item contracts, unlike non-commercial item contracts, the government cannot require the contractor to comply with the cost accounting standards or the contract cost principles outlined in FAR Part 31, nor does the termination for convenience automatically give the government a right to audit the contractor's records. However, the government will not pay for any work or costs incurred that the contractor reasonably could have avoided. The government may terminate a contract for cause in the event of any default by the contractor, or if the contractor fails to comply with any contract terms and conditions or fails to provide the government, upon request, with adequate assurance of future performance. These causes are essentially identical to the three causes found in the FAR Part 49 default clause. When an excusable delay occurs, the contractor must notify the CO as soon as possible after its occurrence. One possible remedy for an excusable delay is for the CO to issue a modification to the delivery schedule. Show cause letters are not necessary in these cases, as the contractor is responsible for notifying the government of any delay or disruption of the delivery schedule. However, cure notices are required prior to terminating a contractor for any reason other than late delivery. In the event of a termination for cause, it is crucial that the contractor assure the government that the contractor will afford the government all remedies available to any buyer in the commercial marketplace. When a termination for cause is effected, the government's preferred remedy is to acquire similar items from another contractor and to charge the defaulting contractor with any excess costs associated with the repurchase. For example, if the price of the items has increased, together with any incidental or consequential damages related to the termination,